Great. So, as I mentioned, this is how to change our relationship to land. My name is Dorian Payan. I'm a staff attorney here at the Law Center. That's me hauling some compost in my farmer days. And this is a little bit of why this topic interests me so much. I used to be a farmer and by happenstance became an attorney. I was really fortunate to find the Law Center and just have the space to continue asking these questions because I was asking them on the field and I feel like I wanted more space to think about these things and do it with other folks. You know, what is our relationship to land? How does it look like now, and how can we imagine something different? So I miss the farm, but I also really appreciate being in this space now. Today, we're going to talk about just basic questions around land. We might hit on different forms of democracy, which is what the description talked about. But I'm realizing that also merits its own separate conversation. And we won't necessarily get into concrete examples today. That's going to be in other presentations down the line. So I just want to say this is the first in a series of many conversations we're hoping to have on how to change our relationship to land. So I'm inviting you all to continue joining us and through the summer, just continue exploring this topic with us. All right, so we're going to do some simulation today. We're going to play a little bit of a thought exercise, a little bit of a game. And I want us to imagine just for a second that you are now the director of the California Bureau of Land Reform. Now, what does that entail? Also, just shout out to these cartoons. This is probably my favorite illustration. So I just want to say, shout out to my mentor, Janelle, and these illustrations. But this is what I am.
Since you're shouting me out, I'm going to interrupt and say the bottom part of your slides is being cut off. I
Oh,
think it's a
interesting.
presenter view thing. Yeah, that's better.
Better.
Does that,
Okay, there you go.
is that okay for you? Okay.
Yeah, that works for me. Thank you for
No,
that.
the whole world. Okay, carry on.
Oh, world. Great. So you are now director of the California Bureau of Land Reform, which miraculously has been a department that has been developed in the state of California. So if you're the director of the California Bureau of Land Reform, well, you're probably going to get briefed. What's the situation of land? What's the situation of agricultural land today? And, well, you realize things are kind of bleak, right? You understand that land ownership in California is pretty bleak. According to the Agricultural Land Equity Task Force report that was recently published, you know that 82% of agricultural land is owned by white producers. And you also know that about 64% of those producers operate on only 10% of all total cropland in California. You also know that land consolidation is increasing, and those consolidating that landholding are often in what's called the farmland investment industry. So the suite of like private equity, insurance companies, institutional landowners. These are pensions like TIAA, for example, which has become the largest institutional landowner in California of agricultural land. And you know that this land is a stable investment vehicle held for the purpose of generating rent. You also know that land that's in production generates about $61.2 billion in output, which is a lot of money. However, you also know that this cash output is largely generated by migrant labor, and especially when it comes to what's called specialty crop production. You know that this migrant labor is often underpaid and overworked, and that many of them lack basic rights. And lastly, you know that food has gone up 30% in price, while wages have largely remained stagnant. So things are great, but this is why your position was created, right? And, well, wait, what is land reform even? For the sake of simplicity, let's draw on a simple yet powerful definition of land reform. Land reform is the answer to what's called the agrarian question. And I draw on this definition of the agrarian question by this peasant studies scholar, Henry Bernstein, which really inspired a lot of my thinking. See, Henry Bernstein saw the advent of capitalism as just one of the key contributors of change to land, which is an obvious point if you've simply lived on this earth for a few minutes and you realize the agrarian question interrogates our relationship to land and unsettles its assumption of how we move on the land, how we work on the land. And in its most basic form, the agrarian question is asking, just how are we relating to land today? So this question is a four-part question. It asks, who owns what? Who does what? Who gets what? And what do they do with it? With the questions you have at hand, well, answering them with the status quo looks something like this. Who owns what? Land is mostly owned by white people, and 90% of that land holding is held in quantities over 50 acres. Who does what? Well, feeding our people, mostly migrant farm workers. Renting the land and making a profit off of it, institutional landowners. Who gets what? The landholding elite, as we said, walk away with the lion's share of those $61.2 billion, while the workers only see a fraction of it. In addition, society at large gets the negative externalities associated with agriculture, which contributes largely to agriculture and to greenhouse gases. And what do they do with it? Well, they enclose the land and make a profit off of it while also making it a scarce resource. So the status quo isn't great, but it becomes your job to ask these questions again and to find new answers to them so that you can answer the agrarian question with land reform, which entails, hopefully, creating a better world than this one. So the first question is going to be, who owns what? Before you can even ask who owns what, though, you have to first ask, what does it even mean to own? Well, you live in the state of California, and the state of California, along with the United States, protects and enshrines property rights as one of the most important rights that an individual can have. I want to stress that this is only a right, though, not a guarantee. And here's a key point. I quote Christian Lund and Hilary Saxon, two scholars that have also inspired a lot of my thinking, who say individualism comes with its own technology, the law and public administration. So the U.S. Constitution's 14th Amendment grants us the right to life, liberty, and, well, property, which cannot be taken away with due process. And it's also enshrined in Article 1 of the California Constitution. All people, it reads, are by nature free and independent and have inalienable rights. Among those are enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. This also means that you're going to need to have a pretty big budget if you want to redistribute land. The takings clause of the Constitution makes it so that you're unable to seize land without just compensation. And that just compensation is determined usually by highest and best use. You also very quickly address the elephant in the room, though. What does it even mean to own indigenous land? Is that even morally possible? If you're the director for the Bureau of Land Reform, can you in your right conscience confer ownership to stolen land? Isn't the injustice that you're trying to solve for the lack of meaningful relationship to land? Have not indigenous people been waiting for a better tomorrow? All right, well, deep breath. What is property? And is it always a bad thing to have? Well, okay. Property in its most basic terms is a right. And in particular, it's the right to exclude. With some conditions, of course. But for better or worse, it's the basis, this technology that mediates our relationship to each other. This is a definition that you find in the Civil Code in California. And it reads, ownership of a thing is the right of one or more persons to possess and use it to the exclusion of others. In this code, the thing of that which there may be ownership is called property. So it's right there, written plain and simple. When you take your property class in law school too, you're introduced to this often seminal piece by Morris Cohen titled Property and Sovereignty. And it also relates property to the idea of why sovereignty exists even in the first place. And it reads, property and sovereignty are inextricably linked. First, property is a product of sovereignty. Without authoritative enforcement to rights, to things, without that is a sovereign, many argue that there is no property. Second, property in effect delegates sovereign rights to owners by creating control over use of valuable resources. Property gives owners legal control over other individuals. So, in other words, what would stop your neighbor from just taking your property and claiming that it's theirs on just any given sunny day? Well, they can't. You have a third entity between you and your neighbor that actually ordains or triangulates who is entitled to what. And so this idea of sovereignty and property is essentially plays out like this. Okay, well, so the second question is, who does what? When we ask who does what, the does suggests that the question is concerned with labor, and in particular, the social division of labor. But if you're the director for the Bureau of Land Reform, you're, for better or worse, filtering this to the answer to the first question of what ownership possibly means. So the question of social division of labor can only be answered with the social division of property as answered. This means you're going to have to explore different manifestations of property, not just property in its given form. In other words, is property something that is always held by the individual? Well, let's look at some definitions and place them on a spectrum. So on the left, we'll have Locke's notion of private property. On the other end, we'll have the commons, popularized by Elinor Ostrom. And somewhere in the middle, we'll have this thing called property owning democracy by John Rawls. So the American standard of property is private property. This phrase that we mentioned earlier, life, liberty, and property, was inspired by an English philosopher named John Locke, who wrote in his second treatise that private property was a right and the role of government was to protect that right. He writes, the great and chief end, therefore, of men's uniting to commonwealth and putting themselves under government is the preservation of their property. And the reason that it was brought into the founding documents of this country was because Thomas Jefferson in particular believed this idea, and he saw it as incredibly compatible with this idea of the yeoman farmer, these small landowners who we called the most precious part of the state. And Locke has this really interesting idea too that's still very prevalent today. It's this idea that mixing your labor with land then turns your land into property. And that's a notion that still carries a lot of force today. This is also why, prior to contact, indigenous people weren't seen as property owners because their labor was not seen as the industrious type that could convert land into property. Okay, well, on the other end of the spectrum, we have the commons. So the commons are a framing of land tenure where land ownership is not the principal objective, but rather its use, and in particular, its shared use. So the commons have existed in countless ways, and they were best popularized by Elinor Ostrom, who observed 8 principles of design for the commons. They were 1, clearly defined boundaries around the use of a resource. 2, rules of fit local circumstances and context. 3, people have agency and control over their decision-making and rules. 4, commons are monitored regularly. 5, there's a system of consequences for rule breakers, and it's fair and graduated. 6, conflict resolution is accessible, and the resources to engage in that are accessible as well. And 7, legitimacy of the commons is recognized by state authority, so there is a right to organize there. And lastly, the resource managed by the commons not only benefits the commons, but it benefits from wider regional protections and cooperation. Somewhere towards the middle left of this spectrum is this other theory, though, that is also a stronghold in political liberalism today, which is to say, a world has been imagined where property is the basis of our relationships, very much like today. but through a more egalitarian tinge in theory. And this is called property owning democracy. So realistically, your position of director for the Bureau of Land Reform exists because people likely envisioned something like this. See, property owning democracy was a term that was popularized by John Rawls, one of the most popular liberal philosophers of the 20th century. And he believed in this concept of justice as fairness, which he envisioned as a foundation for our government and our relationship to each other. Rawls believed that if everyone had equal basic rights, this would create the ideal recipe for a fair society. And one of the ways to achieve a just society, well, was to ensure that everyone was distributed property fairly. Rawls believed that concentrated land ownership and monopolies in general were antithetical to democracy. And this is actually not far off from what people envision when they think of land reform today. It's also worth noting that Rawls believed or was against this idea of what's called the welfare state. And it's essentially saying, you know, there are states that aim to ensure a decent standard of life, but it's not enough to do that, you know, because if you're still able to actually allow large inequities of wealth, even with a baseline, well, then that itself doesn't create a just society. But in this sense, we're still talking about individual ownership. So is there something else that we're missing? Well, there's also social property. And social property is a framework that moves rights from the individual to the community. I'm not going to attempt and describe the totality of social property, but I do want to highlight that it's an alternative to property owning democracy because it enshrines rights often in terms of communities versus individuals. So where Rawls, for example, believed that concentrated land ownership and monopolies in general were antithetical to democracy, those who practice social property and believe in it believe that it was actually individual ownership in general that was a problem. So, for example, Rawls' quote would go something like what he described, but adding, rather than generally, conditional socially, meaning not the individual, but social. And if we look south, for example, we find a very evident use of social property in Mexico. So like Article 27 of the Mexican Constitution brought about land reform. And along with it was a concept of social property in the ejido. The ejido itself, while having individual and familial elements, is ultimately a form of organization that transcends the individual. So you see here the map, a little more than half of what you see here in the maroon is actually social property in Mexico. And of course, it's owned collectively, but even within the social unit, there is land for human settlement. There's common lands and then there's parceled lands. So there is distinguishment within the social property, but the emphasis here is that it's owned by the community and not the individual. All right, next question is who gets what? So in other words, who is the protagonist of the story? Historically, in land reform movements, the slogan has been land to the tiller, which is to say that the peasant, the country dweller, has been the main protagonist of the story. The late British historian Eric Hobsbawm, though, declared that the peasantry is dead in the West, and in fact, that reflects our current condition. In the US, for example, farm employment is only 1.2% of total employment. In California, the number is 2.3 at peak season, and it's still a tiny fraction. That means 2 out of 100. Let's compare this maybe to the 19th century, where the number was roughly 1 in 2. And early in the 20th century, like in the early 1900s, that number was 1 in 5, so about 20%. To now, nationally, it's about 1%, or in California, it's about 2%. So that's not to say that we don't have a group that is in intimate relationship with the land, and often by force. As I mentioned, farm workers are our closest analog to what would be called the peasantry today, which used to often be the main question of the agrarian question. And I think it's still a good starting point because farm workers are incredibly disenfranchised. For example, we know that about half of farm workers today have no work authorization in this country. And the few thousands that actually come to the H-2A programs are essentially conscripted to their employers and don't have even the right to bargain. For example, this lawsuit, Kansas versus U.S. Department of Labor, when there was an effort to extend protections for organization, it came at the Department of Labor saying, hey, actually, the NLRA, what gives everyone their right to collectively bargain, does not include agricultural laborers, and so can't include H-2A workers. So while H-2A workers, while farm workers pay federal and state income taxes, they don't actually see any of those benefits. So we can see why the question of who gets what is critical to the question of land reform today. Now, ironically, there's nothing that prohibits, quote unquote, foreigners from owning real property in California. Article 1, Section 20 of the California Constitution grants the same rights to foreign nationals and non-citizens. And Section 671 of the Civil Code in California also allows non-citizens or foreigners, as the term goes, to own property. But I'll say farm workers are often in a tenuous migratory status. So one is left asking, would the Bureau of Land Reform actually advocate for state funds to be used to increase landholding for non-citizens? And of course, to be clear, our farm workers might not be capital C citizens, but they are our neighbors and they are a part of our social fabric. Last question, okay, is, well, what do they or what do we do with it? Perhaps most important to ask is land for what? Is it to make a living off the land? Is it to have an investment that you can sell towards the end of your life that you can retire on? If you're making a living, what kind of living are you making? Are you engaging in enterprise? Is there enough land for you to do that? See, the American myth of 160 acres that we often talk about is based on this strange agronomy of what it generally took to be self-sufficient in the East Coast. But California is microclimate rich. How do you assess how much land is enough land? And is it so people can homestead? Why did homesteading even cease to be the dominant form of living? Was it as sustainable as we imagined it to be? Would you envision a Jeffersonian democracy once again based on those principles? By now, I hope you're realizing these aren't questions that the state itself probably has the capacity to answer. And it's going to rely a lot of grassroots lobbying guided by popular and participatory movements. At least we hope. Okay. Now we're going on to another part of the simulation. So rather than being the director for the California Bureau of Land Reform, you're now working for the Attorney General. And you have a couple of questions. So you want to flesh out, what are the big concerns that come out of this department? What are the first things you would look to as a potential challenge? In this section, we're just going to discuss 3 legal considerations, 2 of which are related to land and 1 of which is related to civic rights. Land reform historically has consisted of using the tool of expropriation to, as the word suggests, reform the composition of landholding. In the state of California, though, there's already a clear path of expropriations set out, technically. In 1900, at the turn of the 20th century, the courts in San Mateo County versus Coburn reified that what would become known a landmark case that the right of the state to appropriate private property for public use is an element of sovereignty, harkening back to this idea of sovereignty. So the right being here, described here, is called eminent domain. And the process to do that, the way that the right is exercised, is condemnation. This process has been formalized in the Code of Civil Procedure, and it's a right exercised through the act of a civil procedure, which is why it's highlighted in the California Code of Civil Procedure. And of course, because the state of California is nested within the United States, we're beholden to the Fifth Amendment of the Constitution, which states that no property shall be taken for public use without just compensation. We also find this in California Constitution, Article 1, Section 19. So If you're enacting land reform, the shape of justice is primed by property rights. Even if the condemnation is going to benefit the landowner, they're still entitled to compensation. And even so, it's not only through it's only through public use or necessity that you can exercise the power of eminent domain and condemn a property. So let's talk a little more about this concept of public use. What is public use? Turns out that public use is a pretty difficult thing to define, and it's often defined on a case-by-case basis. The term public use itself suggests that the public would make some use of it if the land is condemned. So in this sense, the land is expropriated to the public. The Constitution went on to enumerate a number of things that could be described as public work, for example, but that's not the same thing as public use, ironically. So Section 19 does talk about what a public work is, but it doesn't actually describe what a public use is. And in fact, it was ruled in Reese versus County of San Diego that not all public works are considered public uses even. There's also, of course, our famous case, Kelo versus the City of New London, which is celebrating its 20th anniversary. I believe just celebrated it last year. And I can guarantee if you were born after the 90s, this is why you ever learned about eminent domain to begin with. I myself remember being a child and seeing images of this little pink house standing strong against the tides of unfettered development. So this Supreme Court case introduced to our imaginations that public use could mean something beyond this idea of actual practical use by the public to condemn land. In this instance, the Supreme Court ruled that the City of New London taking private property in order to then sell it to private development, while not being used by the public in this quite literal sense, would still meet a criteria in which the development would service a broader public purpose of economic development. And that itself was qualified as a public use. And this angered many people, like on all ends of the spectrum. It actually led to the passing of Proposition 89 in California, which would ban the condemnation of single-family dwellings with only a number of exceptions. So in this constitution where the definition of public works is, it adds through Prop 99 that the state and local government are prohibited from acquiring owner-occupied residences for the purposes of conveyance to a private person because of Kelo versus City of New London. Okay, well, this leaves us then to imagine land reform, at least currently, strictly through this window. You have public use being defined in the literal sense, and public use being defined in this broader sense. Ultimately, though, public use is decided through either the courts or the legislature. And one thing that I have not yet mentioned is that also the legislature and the courts can decide what public use is. So if the legislature condemns a property and outlines what the public use is, it becomes a valid public use unless challenged by the courts. So, having explored the agrarian question, what would then be a valid public use that would justify land reform? Would we want to explore a public use in the literal sense, where the public is able to make use of the land? Or would we want to argue that redistributing land to formerly disenfranchised people is actually a public use? This would again largely depend on whether we are building a world that values property or values something closer to the commons. The next legal challenge that I imagine us facing would be that related to this pernicious law called the Subdivision Map Act. It's this very innocuous legislature shapes much of how we relate and can relate to land. See, early in statehood, the state of California and its various settlements wanted to know what was happening out there, at least in terms of how the institution of property was developing. And throughout the 19th century, there have been a series of genocides and land grabs that radically altered the land. So there was a growing class of landowners, and they were engaging in land speculation and real estate development themselves. Being able to know who owned what land was a way for the state to know who to levy taxes on, but also provided a repository in the case that competing property interests, property claims came to be resolved in the court. So in 1993, the first version of this thing called the Subdivision Map Act was enacted. And it says, this is an act requiring the recording of maps of cities, towns, additions to cities or towns, or subdivisions of lands into small lots or tracts for the purpose of sale. So, of course, the Subdivision Map Act has developed a lot today, and they look a little different. As anything that interfaces with civil society, the Subdivision Map Act is actually now set to fulfill many different purposes. So, still, as originally intended, the map serves to standardize the land. If you have a map that is uniform and centralized, it's much easier to sell and buy property because you're able to track the chain of ownership and much more clearly assess the lines of the property. Second, as the name suggests, the subdivision map is meant to ensure that there is an allocation of resources so that streets, sewer, and drainage systems, all sorts of infrastructure can be more adequately planned. And of course, most importantly, the Subdivision Map Act promotes coherent planning by creating a language that can tie it to what is called community planning, which is also seen in the general plan. So, if in your vision of land reform, you are changing the composition of land from one where a few people own large tracts of land to one where many people own land, you're eventually going to run into the issue of subdivision because you'll likely be subdividing the land. So let's say you have a 960-acre tract of land, and you're looking to develop this piece of land into 6 pieces worth 160 acres each because, well, we're dreaming big. Anytime you divide the land into 2 or more parcels of land for the sake of what's called conveyance, which means you either sell, you lease, or you finance, although agricultural leases are exempt, you're triggering this thing called the Subdivision Map Act. And so the purpose of all this is, as I mentioned before, to enable it to tie to the general plan. Well, we also want to know, what is a general plan? You can think of a general plan as a city or county's constitution. It outlines a trajectory of physical development that the city or the county anticipates. A general plan is composed of 7 elements. These are land use, circulation, housing, conservation, noise, safety, open space. So a local agency will not adopt a map unless it's consistent with the general plan. So the process of land reform will tug us at the heart of land use in California, obviously. And this means that the legislature of more regional bodies will also be deeply involved with land reform. But of course, there will still be guidance from the state level. For example, the Governor's Office of Land Use and Climate Innovation, LUCI, publishes California's General Plan Guidelines, which guides cities and counties into their implementations of the general plan. Okay, well, this is great. This means we have the opportunity for land reform to be shaped by local politics. But it begs the question, who gets to actually participate in local politics? In other words, who is entitled? The third main legal consideration is assessing who is entitled to land reform and who is entitled to this civic process. Well, California is actually the only state in the country, besides the District of Columbia, ironically, to allow non-citizens to vote. And those 2 sites are actually located here in the Bay Area, where the Law Center is located. In 2016, the city of San Francisco passed Proposition N that allowed parents whose children were part of the San Francisco United School District to vote for the Board of Education. And similarly, in 2022, Proposition S, voters in Oakland approved the city charter to do the same. Los Angeles is actually underway to do the same themselves, but also extending the ability of non-citizens to not only vote in school elections, but in other municipal elections, which is great. However, this proposal has been pushed out until at least 2028, just given the climate. So what does it mean when at least 50% of the agricultural labor force in California will not be able to participate in the civic process? That's a question that we continue to ask ourselves. Okay, there are also other considerations that the state of California takes into account, and these, I imagine, I hope, would shape the process of land reform. The first is Assembly Bill 3089, where Gavin Newsom issued an apology to Native Americans for the state's historic wrongdoing, and that established a Truth and Healing Council. The second would be Senate Bill 518, which established the Bureau for Descendants of American Slavery. and it's an early step towards California enacting reparations. And the third would be N 8220, which established the 30-30 initiative, promising to conserve 30% of California's land and coast by 2030. This is to say that any effort at land reform would have to take these efforts and their imperatives into consideration as well. Now, of course, there's a lot of things that weren't covered, right? Because so much of what we long for with land reform can't adequately, as I mentioned earlier, can't be executed by the state. And in a lot of ways, this was the point. So this third segment briefly talks about how we're slowly patching together land reform and why it might be most important to be grounded here. I think it's important to speak of what actually animates us, what guides our imperative for land reform. And so I just want to talk about these four sort of North Stars or guides that inform the work that we do. And the first and foremost is that we cultivate cooperation everywhere. We spread power whenever possible. The second is land back. So nothing about land without the conservation, the conversation of rematriation. The third is constructive reparations. So world building as a form of reparations. And the fourth is that land is a public good, not a luxury. We eat because we live. So we talk about democracy, which we believe should be an essential, or cooperation, which we believe should be an essential component of cooperation, or democracy being an essential component of cooperation. And even within cooperation, though, I just want to note that there is a spectrum, and we can observe the same thing here. So, for example, on one end, we have this idea of what I would call the Louis Calso School of Cooperation. And Louis Calso is this economist, a banker and a lawyer from San Francisco who co-wrote a book called The Capitalist Manifesto. And he argued that a new capitalism was necessary, where capital investments could be reaped by the workers. And he argued that this thing called employee stock ownership plans could be a way for workers to gain ownership in their companies, become much more productive, knowing that the business, in theory, belonged to them. So the stock itself would come from money that would be borrowed by that company and then would be repaid by the workers. In this system, much of our existing systems stay intact, but the introduction of social property in the form of ESOPs or employee stock ownership plans answers the question of who gets what directly. On the other end, I'd say is democratic governance, where deliberation is made together. This isn't to say that every decision is being made by all the people at all times, but it's creating a structure where you're able to meaningfully direct yourself as a person. So in the context of land, the Calso model of cooperation, as I call it, would best align with this idea of maybe property owning democracy. It would essentially mean that each person would have a stake in property and hopefully social property. So rather than stock in a company, you would hold stake in the landscape. The challenging part here is that, no property, no sliver of land is the same. It's not the same as handing out stock. Land is much differently. You can't standardize it in the same way that you could possibly standardize stock. And in a lot of instances, this land would be owned at the family level, which also presents many problems to democracy as well. Well, so how do we expand the forum for democracy to even happen? How do we reimagine this idea of property so that we're able to think of resources not as an amalgamation of individual stakeholders, but rather as one big common pool? Well, I do have hope that rather than it being a spectrum, as I mentioned here, it's a little more like this circle at the bottom right. And we can actually, so that, we can see that something like property owning democracy or something like property serves as a smaller function of cooperation, and it doesn't become the basis of cooperative relationships. It only has its proportionate place. This also just reminds you of this really wonderful slide that my mentor made at one point. So just leaving this here for now it's a really nice thought exercise for me. Okay, the second tenet is land back. So what would it mean to think of land reform through the lens of rematriation? For starters, well, there wouldn't be any land to redistribute, but only land to rematriate. So rematriation looks a million ways because, well, indigenous people express themselves culturally in 1 million ways as well. We talked about this idea early on of sovereignty and property rights being mutually reinforcing, but many indigenous writers have refuted this assertion. For example, Leanne Simpson, an Anishinaabe writer, through this phrase that she uses called Kinagichi Anishinaabe Ogamig, calls it for the inherent sovereignty that we are all born with. And this translates directly to sovereignty is the place where we all live and work together. But it always relates to the sovereignty of the body. And I think this stands in stark opposition to this idea that sovereignty is something that is granted, that is only engendered when property is made possible. This is where the idea of, for example, the commons has actual potential. And in many ways, we know that the commons is a Western word, but it's being retrofitted in the service of rematriation. It's actually made for really creative expressions. It opens up different possibilities for relationships with the land that are themselves rooted in rematriation. The third is this idea called constructive reparations. I borrowed this term from Olufemi Taiwo. Olufemi says, the project of reparations is to learn how to distribute capabilities justly in order to make a new world. And such a just world must be, by its nature, fundamentally incompatible with the one that we are in now. The world of global racial empire in which laws and norms maintain the unjust distribution of racial capitalism. What is this capabilities term? Well, he goes on to define capabilities as well. And he says that capabilities are this capacity to achieve functioning. In this case, the physical ability to actually feed oneself and the financial and environmental ability to access nourishing food. So while yes, this means land, it doesn't necessarily mean property. And most importantly, it means contending with the landscape memory of grief. If we are inheriting the land, what events that happen on the land are we also inheriting with it? And how do we make sure that those events never happen again? All right. And the fourth and final tenet is that of land as a public good. And by extension, all of the things that we need to provision for ourselves, those capabilities that we need for us to thrive. See, a public good is defined by two dimensions. One is that it has to be non-rivalrous, and the second is that it has to be non-excludable. So something that is non-rivalrous means that it's not mutually exclusive. One person having access to or enjoying a good does not preclude other people from doing the same. So this idea of the right to exclude really collapses when you think of land as a public good. And of course, that's what the second dimension says, non-excludable. It means that people can't be prevented from using it and benefiting it from that good. The public good itself is actually also often intangible. So while we're talking about the land, we're not necessarily talking about access to the land itself. We're talking about the capabilities that it offers. Intangible as that might be, though, that, of course, does translate back materially. So I can go as far to imagine that Indigenous sovereignty is a public good because it offers the ability for a cultural rhythm, this cultural practice, which ultimately has its imprint on the land to be able to thrive and exist among us. But it gets to another point very much related to this, which is this concept of infrastructural citizenship. And that is that what we build and tend to is the basis of our connection to our basic needs, rather than some citizenship attached to privileges afforded by a particular state. And in a lot of ways, it actually transcends the state because it acknowledges that we are just one continuous web of connection. It's what the author Deb Chatra, which actually introduced me to this term, calls what's called care at scale. Okay, well, to recap, the agrarian question can't be answered by the state with the logic of the state. Large legal frameworks are grounded in and perpetuate only one reality often. Starting with liberatory commitments, I think opens the possibility to imagine more expansively. And well, I truly do hope that I've left you with more questions and answers in our time together, because that was kind of the purpose. And I also have these questions for you. I'd love to either open it. I was maybe hoping to do breakout rooms, but I think maybe we'll do just some Q&As and reflections. But maybe some questions for you to walk away with. We got to answer the agrarian question today. Is property worth bequeathing to our future generations? Is that a legacy that we want to leave? How can we ensure that belonging and capabilities for everyday life beyond citizenship exist? What other guides would you offer? Thank you for coming today. I think I'd love to open it for reflection.